So today our group members is Muhammad Akil Zarif bin Nur Faizal, matric number 210118. Me, Muhammad Taqif Adam Wong bin Alif Nazmi Wong, 211647. And then we have Salamullah bin Kamsul, 2030370, and Muhammad Fahan bin Abdul Rahman, 209846. Okay, next slide. So this is the summary of our case, which is the 1MDB case. So 1MDB has filed a total of 6 separate suits, including against foreign banks, Deutsche Bank, JP Morgan, and Coats & Co. One of the 6 suits filed is against Deutsche Bank Malaysia Limited, Coats & Co Limited, JP Morgan Switzerland Limited, and 2 Petro-Saudi companies for alleged negligence, breach of a contract, conspiracy to defraud the company, and dishonest assistance to defraud to the total amount of 4.923 billion US dollars. That is about 20.22 billion ringgit Malaysia. Okay, next. The first lawsuit was filed in Malaysia by 1MDB and its subsidiaries as a way to lure foreign parties, including Joe Low, to come and defend these actions in Malaysia jurisdiction. The causes of action against them are for fraudulent misrepresentation, fraudulent breach of duties, fraudulent breach of trust, breach of statutory and contractual duties, conspiracy, negligence, knowing receipt, dishonest assistance, fraudulent misappropriation, and unjust enrichment, where the quantum sought is for $7.795 billion. So these are among the sued individuals, which include Datuk Sri Najib Razak, Tan Sri Muhammad Irwan Seriga, Datuk Syahrul Ibrahim Halmi, and Arul Kandasamy. The second lawsuit was filed against Irwan and Arul Kanda for various crimes, including alleged breach of fiduciary duty, fraud, conspiracy, breach of trust, and dishonest assistance. 1MDB is claiming 6.59 billion US dollar from the duo as a result of the perpetrated breach, and an additional 2.9 million ringgit against Irwan Seriga for fraudulent breach of duties and trust resulting in the extension employment agreement. The third suits involve foreign financial institutions, which includes Deutsche Bank, Coats & Co Switzerland, and JP Morgan Switzerland, along with Petro-Saudi International and Petro-Saudi Holdings Cayman Limited, as well as its co-founder Tariq Obaid and director Patrick Mohani. This financial institution was filed for lawsuit due to breach of contract, conspiracy to defraud, and dishonest assistance. 1MDB also filed claims against Joe Low, his father Hock Peng, sister Maylin, and his close associate Eric Tan for fraudulent concealment, fraudulent misappropriation of funds, unjust enrichment, breach of trust, and conspiracy, where a total of $1.402 billion are sought from them. Lastly, the action against legal firm Wong and Partners, along with its senior partner Chia, is for perpetrated breach of contractual, statutory common law, and fiduciary duties, as well as dishonest assistance in misappropriation of funds.
Here are some of the former directors who breached the law by the Section 213, Subsection 1 of Company Act 2016. We have Najib Razak, former chairman of 1MDB Advisory Board, Tan Sri Cik Lodin Wok, 1MDB 1MDB former chairman Tan Sri Ismail and many more directors. Those directors who actually must exercise his power with proper purpose for the best interest of company. The director also must not use the company to make secret or personal profit without approval from the company. The case of 1MDB has some similar case law, which is first v. Tom case. Because in 1MDB, all of those dependent that being sued by 1MDB company was either directors, high-ranked officers, and associates of the company who misused their position to make secret profits and money laundering for personal benefits. And we move to the sanction of the case. All of the sued person has been banned from leaving Malaysia by Malaysian Immigration Department and has been banned from traveling outside Malaysia. Najib was later charged with criminal breach of trust, money laundering, and abuse of power, while alleged mastermind Joe Low, by then an international fugitive, was charged with money laundering and has many multiple suits. The final edict by the court says that Najib was subsequently found guilty of 7 charges connected to SRC International, 1MDB subsidiary, and was sentenced to 12 years imprisonment and fined 210 million ringgit.
All right, so on my part, I will present to you the suggestion to be charged. So as you can see, the news from the change now is specifically the 1MDB use of application power. So what we can understand is specifically the suggestion that comes forward is basically the same with what an MDB did, which is basically through the director. Because this is the one way to avoid from being charged by the report of the advisor, which is, for example, Michael Shagab. Because before this, we learned about that the company is living within the separate legal entity concept. Therefore, according to the law, we cannot sue the person inside the company due to the separate legal entity. But then we do learn about lifting up a corporate bill where we see this director, director doing breaching the trust of the company, director committing fraud. We can actually go to the court and ask the court to lift up the corporate bill so that the company can decide to sue the director. And yeah, finally, the company will be free from the charge, and the person that is specifically responsible behind all of those fraud things can take their responsibility.
Okay, thank you. So for the lesson learned for this issue, so the 1MDB scandal revealed the weakness in the regulatory oversight and enforcement mechanism. So it highlights the need of the independent regulatory body with adequate power to investigate the financial misconduct and hold the wrongdoers accountable. So the lesson learned is a regulatory system where the importance of frequently reviewing and improving the regulatory system to stop the and avoid the similar power abuse and financial crime. So next is the promoting financial transparency. The lack of the financial transparency was a critical factor in the 1MDB scandal, whereas it emphasized the importance of the promoting transparency in the financial transaction, where public procurement process and the political financing. So the lesson learned is the demand for the throughout and accessible disclosure guideline, accountability procedure, and public monitoring may be important to protect against the fraud and guarantee the responsible use of the public monies. So, and lastly is director responsibility. So, director plays a critical role in overseeing the management of the company and ensuring the compliance with the law and regulation. So, in this case of the 1MDB,
case emphasized the importance of the establishing the corporate governance structure, including independent board oversight, risk management system, and internal control. So for the director's responsibility, the lesson that we learn is that in order to avoid the financial fraudulent conduct, director must actively participate in the governance, comprehend the business, and use their own discretion. I think that's all from us. Thank you.
Thank you. In this case, do you have any proof that Najib was sued under his own capacity as director and the court actually lift up the veil? Or is that your own facts? I mean, is that your own
That is my own
conclusion?
suggestion.
No, you cannot make suggestion for the case that has been decided by the court. You have to look at the judgment of the court. This is not correct because you cannot make suggestion when the court already made judgment. You are saying something when the court did not say. Do you understand what I'm saying? I mean,
Yes,
you are trying to apply what you learn. I understand, but you know, in this case, actually, the court already made judgment, isn't it?
Yep.
Yep. Right. So you should find the case and see. You should not. We can't, because if they're involved, then the court, I mean, the lawyers will already bring up this matter and the court will make a judgment in this. But I don't think he was sued under his personal capacity as a director, right? I mean, by using a corporate veil, isn't it?
Because my part is still like suggestion, right? So I thought that perhaps try to implement any knowledge that I learned in the class into the real case scenario. That is what I thought back then.
Yeah, I understand. By using real case scenario is good, but then it doesn't suit. If it suits, then the lawyer will lift up the corporate veil. Am I right? I mean, and then when you make suggestion, not necessarily you have to make new suggestion. I'm not saying that you are wrong. I'm not commenting on you personally, individually. I'm not, yeah, Farhan, I did not. To all of you, when you have to make suggestion, basically, you can refer to how can they prevent what they shouldn't do. That's what I mean. Okay? All right. Thank you so much.
Doctor.
Thank you, Doctor.